Thank you, Chair. And thank you to the witnesses for your attendance today on this important study. I'm going to read to you a portion of a mandate letter that Justin Trudeau supplied to one of his ministers, Minister Anand. Talked about raising the bar on openness, effectiveness, and transparency in government. Says it also means humility and continuing to acknowledge mistakes when we make them. Canadians do not expect us to be perfect. They expect us to be diligent, honest, open, and sincere in our efforts to serve the public interest. Yet February 7, 2019, the Globe and Mail cites unnamed sources, reports that Justin Trudeau and his aides attempted to pressure Jody Wilson-Raybould while she was AG to intervene in the prosecution of SNC, and that exasperation and her lack of cooperation was one reason for shuffling her out of the justice portfolio. Justin Trudeau, when pressed by reporters at some event in Canada, looked Canadians right in the eye and said the Globe story was false. He lied to Canadians. He ultimately received your report, Mr. Dion. He says, well, he disagrees with some of the findings. He accepts the report and takes responsibility for the mistakes that he made, whatever that means. He didn't elaborate. We all know your conclusions. Your conclusions were well founded. Your conclusions were based on all the evidence that you received. You took it upon yourself, I believe, Mr. Dion, to identify all the relevant witnesses and the evidence that you hoped to be able to discharge your responsibility. Is that correct? And I've totaled 14 individuals that you ultimately either interviewed or received by way of affidavit or some other written documentation. I contrast that to the RCMP. And I can't express how profoundly disappointed I am as a member of Parliament, but as a former officer of the court and a former Crown attorney of the shipshod way that they conducted this investigation. They only interviewed Jody Wilson-Raybould twice. They interviewed Jessica Prince, her chief of staff. They interviewed Natalie Drouin, Deputy Attorney General, and nobody else. And when I asked the commissioner not too long ago, why didn't he actually seek out some information from the Prime Minister himself, the person of interest? They didn't think that they had sufficient grounds to do that. That really disturbs me, sir. I'm not going to be asking you about RCMP decisions, but what I am going to ask you about is when you interviewed Justin Trudeau, was he forthright with you? Did you get the impression he was giving you all the information that you requested? Was he holding anything back?
So I recall the interview vividly. It was long, over 2 hours. Prime Minister was accompanied by a few lawyers. And he did respond to every question we asked. There was no feeling of resistance or trying to indirectly avoid questions. He did provide answers to every question that we had.
Okay. Your standard of referral to the police, I believe you said, is on reasonable grounds. Is that a reasonable ground test? And perhaps to Mr. Is it Aquilino? Is it the same reasonable ground test that law enforcement uses in terms of laying a charge?
I believe so, yes.
Okay. So, and again to Michael and to you, Mr. Dion, we all know that there's two elements to any criminal offense, the actus reus, the mens reus. The actus reus is the act of the pressure exerted, either by Justin Trudeau himself or his aides. The mens rea requires a specific intent. Now, I want to circle back to your report, Mr. Dion, paragraph 284. I'm going to read it out to you. It's very, very, very brief. Here, in contrast, the evidence abundantly shows that Mr. Trudeau knowingly, the operative word, knowingly, emphasis mine, sought to influence Ms. Wilson-Raybould both directly and through the actions of the agents. That's the operative term I look for as a former Crown attorney. So I'd like to know your opinion, perhaps Mr. Aquilino, in terms of the reasonable ground test. Did that not give you the ability to make that referral based on that finding?
I think that those are legal issues. The criminal side, the Conflict of Interest Act, knowingly in the context does not necessarily mean knowingly for the mens rea purposes under the criminal code. That's a legal issue. So, Michael.
Well, I disagree respectfully. I think it knowingly means the same thing.